welcome to Chapter 6, the Court System and Alternative Dispute Resolution. As we talked about in Chapter 5, the American system of laws is based on numerous sources. Paralegals, and particularly paralegals involved in litigation, need to understand the different types of courts in the American system. There are 52 court systems in the U.S. Of course, there's one for each of the 50 states, one in the District of Columbia, and one that comprises the federal system, again for 52 in all. First, we'll examine the basic judicial requirements, followed by the structure of the American courts. Next, we'll examine the system of private dispute resolution mechanisms, which are considered alternative methods that avoid the time, money, and publicity that can come with the court system. Let's start with some basic judicial requirements that are common to all court systems. First of all, standing to sue. To bring a lawsuit before a court, a party must have standing to sue or sufficient stake in the matter to justify seeking relief through the court system. In some cases, a person will have standing to sue on behalf of another person. Standing also requires that controversy at issue be justiciable, is real and substantial as opposed to hypothetical or academic. The next of our basic judicial requirements is jurisdiction. In order to hear a case, a court must have jurisdiction over the person whom the suit is brought, or over the property involved in the suit, as well as over the subject matter. First, let's talk about jurisdiction over persons. Courts can exercise personal jurisdiction, which is called in personam jurisdiction, over residents of a certain geographic area. For example, a state trial court usually has authority over residents of a county or district within that state. Long-arm statutes allow state courts to exercise personal jurisdiction over non-resident defendants, such as individuals or corporations from other states. Non-residents must have minimum contacts with the state before the court can exercise jurisdiction. A state court may also be able to exercise jurisdiction over a corporation in another country. Next is jurisdiction over property. Courts can exercise jurisdiction over property which is called in rem jurisdiction, property that is located within their boundaries. This is valid even if the people involved are not within the court's boundaries. Finally, jurisdiction over subject matter. Jurisdiction over subject matter is a second limitation on the types of cases the court can hear. Some courts are courts of general jurisdiction, others are courts of limited jurisdiction. Courts of general jurisdiction can hear a variety of cases, such as civil and criminal cases. However, courts of limited jurisdiction are limited to those over which they have jurisdiction. An example of a limited subject matter jurisdiction is a probate court, which is a state court that handles only matters relating to the transfer of a person's assets and obligations on that person's death. An example of a federal court of limited subject matter jurisdiction is a bankruptcy court, which handles only proceedings governed by bankruptcy law, which is a federal law. Subject matter jurisdiction is defined by the statute or constitution creating the court. The court's subject matter jurisdiction can be limited by the subject matter of the lawsuit, the amount of money in controversy, whether the case is a felony or a misdemeanor, whether the proceeding is a trial or an appeal. We also need to talk about original and appellate jurisdiction. The distinction between these types of jurisdiction depends on whether the case is being heard for the first time. Courts that have original jurisdiction have the power to hear a case for the first time. This power is usually given to the trial courts, and this is the courts that most people think of when they think about trials going on. Courts that have appellate jurisdiction have the power to review decisions of lower courts. This power is usually given to appellate courts. Let's talk about the jurisdiction of federal courts. Article 3, Section 2 of the U.S. Constitution establishes the authority of the federal courts and states that the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. Whenever a case is based, at least in part, on the U.S. Constitution, a treaty or a federal law, then a federal question arises, and the case comes under the judicial power of the federal courts. Any lawsuit involving a federal question can originate in a federal district or trial court. Federal district courts can also exercise original jurisdiction over cases involving diversity of citizenship, which arises when a lawsuit involves citizens of different states, citizens of a foreign country and citizens of a state or different states, citizens of a state and citizens or subjects of a foreign country, when the amount in controversy in a diversity case is over $75,000. Concurrent jurisdiction exists when two different courts have the power to hear the same case. Exclusive jurisdiction exists when a case can be heard only by a certain court. For example, federal courts have exclusive jurisdiction over cases involving federal crimes, bankruptcy, patents, trademarks, and copyrights. When concurrent jurisdiction exists, a party has a choice of whether to bring a suit in federal or state court. Venue is concerned with the most appropriate location for a trial, and it reflects the policy that a court trying a suit should be in the geographic area, usually in the county, in which the parties involved in the lawsuit reside, or in which the incident leading to the lawsuit has occurred. The final in our basic judicial requirements common to all courts is judicial procedures. Litigation follows specifically designated procedural rules. General procedural rules for federal civil court cases are set forth in the Federal Rules of Civil Procedure. General procedural rules for federal criminal court cases are set forth in the Federal Rules of Criminal Procedure. State rules vary from state to state and even from court to court within a state. Paralegals working in litigation must be familiar with the procedural rules of the courts in which they work. Next, let's talk about the individual court systems. First, as we said, each state has its own system of courts, and no two state systems are the same. Each state has trial courts, which are presided over by a judge who issues a decision on the matter before the court. If it's a jury trial, many trials are held without juries. If it's a jury trial, the jury will decide the facts and the judge will issue the judgment based on the jury's conclusion. During the trial, the attorneys introduce evidence to support their client's positions. Each attorney has the opportunity to cross-examine witnesses of the opposing party and rebut evidence. This sounds a lot like courts that most people think of when you talk to them about the court system. State courts also have general and limited jurisdiction courts and appellate and reviewing courts. Appellate and reviewing courts are where parties will bring a reversible error or a legal error that was made at the trial court level. It must be significant enough to have affected the outcome of the case. Usually appellate courts do not look to questions of fact, but rather questions of law, and only a judge, not a jury, can rule on questions of law. About 3/4 of the states have intermediate appellate courts, or IACs. These are courts of appeal. Subject matter jurisdiction of these courts is limited to hearing appeals from the trial courts. An appellate court panel of 3 or more judges reviews the record of the case on appeal, including a trial transcript, reads the appellate briefs, and hears oral arguments from the attorneys to determine whether the trial court committed an error of law. All states also have their highest appellate court, usually called a Supreme Court, although it may be called something else. For example, in New York and Maryland, it's called the Court of Appeals. The decisions of each state highest court are final. Only when issues of federal law are involved can a decision made by a state's highest court be overruled by the U.S. Supreme Court. The federal court system is also based on a 3-tiered model, with U.S. district courts, courts of appeals, and the United States Supreme Court sitting at its apex. Federal court judges are appointed by the president, and federal judges receive lifetime appointments. U.S. district courts, or trial courts of general jurisdiction, and various courts of limited jurisdiction are included in this 3-tier system. The U.S. Courts of Appeals is the intermediate court of appeals. Article 3 of the U.S. Constitution states that there is only one national Supreme Court. That's what we know as the U.S. Supreme Court. Federal court judges are appointed by the President of the United States and confirmed by the Senate, and again, they receive lifetime appointments. U.S. district courts are federal trial courts of general jurisdiction. There's at least one of these in every state. Currently, there are 94 judicial districts across the country. Some states obviously have more than one district. These courts have original jurisdiction in matters of federal law. There are 13 U.S. Courts of Appeals, also referred to as U.S. Circuit Courts of Appeals. 12 of the circuit courts hear appeals from the federal district courts located within their geographic circuit. The 13th, called the Federal Circuit, has national appellate jurisdiction over certain types of federal cases, such as cases involving patent law and cases involving contract claims against the U.S. government. Here is a map showing the boundaries of the U.S. Courts of Appeals and District Courts. Take a pause here and see if you can find your federal circuit and your judicial district. Any party who is unhappy with a federal district court's decision may appeal the decision to the Federal Circuit Court of Appeals, where a panel of 3 or more judges will review the decision made by the trial court for errors of law. The decisions of the Courts of Appeals are final in most cases, but review by the U.S. Supreme Court is possible. The U.S. Supreme Court is the highest level of the 3-tiered model of the federal court system. It consists of 9 Supreme Court justices. and most of its work is as an appeals court. There's no absolute right of appeal to the U.S. Supreme Court. To bring a case before the court, a party requests the court to issue a writ of certiorari. A writ of certiorari is an order issued by the Supreme Court to a lower court requiring the lower court to send it the record of the case for review, and 4 out of 9 justices must agree to do so. A denial for a petition of certiorari is not a decision on the merits of the case. Petitions are granted by the court in cases that raise important constitutional questions or in cases where lower court decisions conflict with other state federal courts' decisions. Finally, today I want to talk to you briefly about alternative dispute resolution. Alternative dispute resolution, otherwise known as ADR, is growing more and more popular as a means of settling disputes because litigation is expensive, adversarial, and time-consuming. ADR, on the other hand, is flexible since the parties have control over how the dispute will be settled, what procedures will be used, whether the decision reached will be legally binding or non-binding. About 95% of all civil lawsuits are settled before trial, often through some form of ADR. More than half of the states either require or encourage parties to undertake ADR prior to trial. Many methods of ADR have been devised and employed, and new combinations of existing methods are also used. What we talked about today was the idea that courts have jurisdiction over persons and businesses residing in the geographic area of the court. Limited jurisdiction exists when a court is limited to a specific subject matter. Court of Appeals or reviewing courts have appellate jurisdiction, and jurisdiction exists in federal court when a federal question is involved. The focus on appeal is for reversible errors in law made at trial. The Supreme Court, remember, has original jurisdiction in a few cases, but it functions primarily as an appellate court. The costs and time-consuming character of litigation, as well as the public nature of court proceedings, have caused many to turn to ADR for settling agreements. Again, I hope you found this lecture helpful, and please follow up by finishing your assignment, which can be found on Blackboard.